You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by the star of the program, Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Good to see you, Bill.
Good day.
So we have a case of the week top story, but it's not even a case that's happened yet. When it does, it's going to focus on the new fee guidelines promulgated by the United States Trustee's Office earlier this month. Bill, walk us through the guidelines. Has a lot of people worked up. Tell us why it's so controversial.
Well, because heaven forbid, lawyers in bankruptcy court are going to have to disclose what they actually bill or collect from their clients, not what their posted rates are. Now, as a little background, I've heard for the last few years that if you are a private client paying a substantial amount of money every month to a law firm on a recurring basis, you will, chances are, be able to negotiate a nifty reduction from the posted hourly rates. So the United States trustees in this country are concerned that as a result in bankruptcy, where bankruptcy judges, at least in New York and Delaware, pretty routinely pay the posted rates, that as a result, bankruptcy has become a specialization in which the lawyers get paid a premium over their brothers and sisters at the same firm who are in non-bankruptcy work.
Right. And what's wrong with that? Bankruptcy is awfully hard.
It is
right?
Extremely hard. And I'm not taking any position about what's right or wrong, but this is what the United States trustees are going to require, is the disclosure of what you actually either bill or collect from your non-bankrupt clients. This raises a couple of questions in my mind. Number one, I am guessing that some law firms, if not many or most, are going to try to have this disclosure held in secret, sealed in other words, so that the world at large is not going to know what they actually bill or collect from their non-bankrupt clients. Whether the courts allow it to be sealed, I don't know. We'll have to wait and see. The other eventuality I expect is that some law firms are going to say these guidelines are just that. They don't have the force of law, and therefore the courts should not enforce them, much less even consider them. I don't think exactly that that's going to work because, the U.S. trustees can take whatever position they want. They're just another litigant. But this is going to be some interesting stuff. You know what's going to hit the fan come November, because that's when these guidelines become effective.
And we have a Judge of the Week. This week it's Kathy Surratt-States from St. Louis. She took over the Patriot Coal reorganization after the coal producers case was kicked out of New York. Her efforts to keep the case or the company alive, however, might be coming undone. If that happens, who's to blame here?
Oh, boy. Well, sad to say, if that happens, it's the workers themselves. The judge wrote a masterful 100-plus page opinion giving reasons why Patriot Coal should be allowed to modify wages and benefits for Patriot and its retired coal miners. The union didn't like it one little bit. They are going to hold a strike vote around the end of June to decide whether to walk out in protest. This case, Lee, could turn out being just exactly like Hostess Brands, the baker of Wonder Bread. In that case, the New York bankruptcy judge said, yes, you can reduce wages and benefits. The bakery workers union says, well, you can try, but we're going to strike. They did, and guess what? The company folded and liquidated with the loss of thousands of jobs. Yikes. The same could happen for Patriot.
Ugly stuff. Bill, we have 3 nice new bankruptcy filings that came into the system in the past 2 weeks. What are they, and ultimately, how do you see these cases faring?
Well, tough question, but I'll see what I can come up with. First, we have Exide, the lead-acid battery maker. It's a Chapter 22 case. They are back in Chapter 11, ergo Chapter 22. The vultures are all over Exide, which leads me to believe that that puppy will come out of Chapter 11 a second time. Whether it can manage to survive after it emerges is yet to be seen.
Bill, it's generally harder for 22s to make it through the system. You can say that, right?
Very, very hard. That's exactly right. The other new nice case is National Envelope. I guess you might call the company euphemistically National Buggy Whip. because envelopes are not used as much as they used to be in view of the internet. This also is a second time around proposition. I have great concern about whether this company will survive. Chances are people will at least buy the customer lists and maybe technology and stuff like that they have, but whether anybody needs the productive capacity is yet to be seen. The last is the most recent case. That is Orchard Supply. That is a chain of 91 hardware stores that was spun off a couple of years ago from, of all people, Sears, because I guess Sears realized that this puppy was headed in the wrong direction. Competitor Lowe's, a store that I like very much, is buying 60 of the 91 locations. So I guess it looks like a lock that that is a company that in largest part is going to continue in business.
All right. Let's do some advance sheets. We have two cases of note this week. One is in the Supreme Court, and the other one is in the 11th Circuit. Tell us about them.
Well, the first is one that will actually happen around the end of the year. In the Supreme Court, the case is called Law versus Siegel, a really wonderful name for a case, Law versus Siegel. This is going to decide a really nifty issue about whether or not a bankruptcy judge has the power to take otherwise exempted property away from an individual bankrupt because of that person's basically bad conduct. Now, this seems to me to be a rather slippery slope to have rather amorphous standards under which a bankruptcy judge can take property away from somebody that bankrupt is under state law entitled to keep despite bankruptcy. I'm not about to guess how this thing might go down. It's possible that the certiorari will be, shall we say, revoked for having been improvidently granted for reasons, if I had another 10 minutes, I could explain. In any event, the other interesting case is out of the 11th Circuit in Atlanta, a case called CompuCredit. If you are in the 11th Circuit, you better go and read all of these decisions. It is very interesting. The background is that 20 or so years ago, two other circuit courts of appeal, one of them in New York, held that when two or more creditors got together before bankruptcy to negotiate with a financially distressed company, that was not, repeat, not an antitrust violation. The same issue came up in lower courts in the 11th Circuit, and the two lower courts held, yes, there is no antitrust violation, but get this, Lee, the case went to the 11th Circuit, and they hung 5-5 because it was argued en banc before all of the active judges. Because they were evenly split, the result from the lower court remained in effect. But what it also means is there is no law right now in the 11th Circuit on whether or not there is an antitrust violation for creditors negotiating together before bankruptcy. There are several implications for this. Number one, as I said, if you're in the 11th Circuit, you may better be a little cautious about negotiating collectively before bankruptcy. The other is, if they can ever get a majority on the 11th Circuit to vote that it is an antitrust violation, then we have an issue I think would be snapped up instantly by the Supreme Court.
All right, Bill, thanks for that. That's what we have for this week. If you'd like to learn more about the cases and issues we just ran through, be sure to go pick up Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. You can see more of our videos on YouTube. You can follow our updates, of course, on Twitter. I'm Pacchia. Thanks for watching, and see you next week.